Good morning, good afternoon, good evening, whichever it is for you. We're here for Chapter 7 of Court Procedure and Evidence here at Wake Tech for the spring 2023 semester, and we're working our way through the textbook for the class. That's Criminal Procedure by Joel Samara. That's the 10th edition, published by Cengage Publishing. So we're going to look at Chapter 7 today. We're continuing kind of looking at searches here. And this chapter is going to be about special needs searches, which is kind of an unusual name to call it, but that was your text option, so we'll go there. All right, so the Supreme Court has applied Fourth Amendment searches to a lot of searches that go beyond simple law enforcement. And we're going to start looking at some of these unusual searches. Some of these, of course, are done by private parties. Some of them are done in a non-law enforcement area. You'll see what special needs means in a minute. It's kind of, like I said, an unusual term for your text to use, but it's not an unknown term. So let's look at 6 of them that we could talk about. Well, there's inventory searches. So again, we're going to go through these in some detail, but I'm going to give you a very quick overview of each one here. So an inventory search would be, let's suppose you arrested someone, or you pulled someone over DUI and you towed their car. Well, if you just arrested a person, when you book them, you're going to take his wallet, and there might be cash in the wallet or cards or other things. So you would do an inventory of what he had on him physically. Also, if you towed a car and you took it to an impoundment lot, there's going to be a search there for what's in the car. There might be something perishable. I mean, God forbid, there might be a small child in the back seat asleep or something, so you wouldn't want that. There's international border searches. The Constitution kind of goes up to, but not quite in contact with, the international border. And for the United States, by and large, we've got a few islands that would change that. But think about the border with Canada, the border with Mexico, and then people flying into the country in airports. So here in Raleigh, I'm recording this in Raleigh, North Carolina. We've got RDU Airport, Raleigh-Durham Airport. It has international flights. You have people coming in from England and from Mexico and from France and from Germany and every place. So as they come in, there's going to be searches there. We'll talk about that, which obviously leads to the next one, airport searches. Not all airports are international airports, so you can go to a small airport and there's no international travel. But obviously, planes have airports themselves are subject to kind of unique searches. There's custody-related searches when you have someone in physical custody, and this goes back a little bit to your inventory. Then there's employee drug searching and testing, because anytime a person is an employee and you test them for anything, that is a search. And then finally, you've got student searches. So whether we're looking at a student that is searched in a high school or in a college, and you can see these are not necessarily law enforcement. Okay, so the characteristics of special needs searches, 4 common characteristics. One, they're not really focused on a criminal. So we're not looking at getting someone who has committed a crime, or we suspect who's committing a crime. So very often what these searches will do is they will discover a crime, but it's by and large, put this in parentheses, unintentional. Which leads to the next block over there. They can result in criminal prosecution and conviction. There's no question that I might search an airplane bag coming into the United States, and if I find cocaine or if I find uranium, that can lead to a criminal prosecution and a conviction. The third thing that makes these kind of unique is they don't require warrants or probable cause, which really is going to mean that we're going to have to come up with constitutional exceptions, because if you read the Constitution of the United States, it says you're going to have a warrant if you're going to have a search. Well, this is a special search, we're saying, so we don't need a warrant and we don't need probable cause. So what do we have to do there? Well, we have to do that 4th block. We have to balance the special needs of the government versus, again, our privacy. So much of the law is a balancing test. It's two or more things in conflict with each other, and we use the law as a neutral referee. All right, let's go to our first one of the most common ones. We got a couple of slides on that. This is inventory searches. So this is really built upon the idea that very often the police are going to bring things into custody that are, you know, not as, not common necessarily. And by and large, I guess inventory search is probably the largest body of them are automobiles. So we have this example here based upon a reliable call. Officers went to the scene of men with guns. At the scene, one man got in his car and then was stopped. During a pat-down, a gun was found and he was arrested. Now, so you had some people, we're going to just assume here that it is an unlawful possession of the firearm. Now, I know at least two states in the United States, I believe it's Vermont and Alabama, have no concealed carry permit. So you can carry a gun concealed and you don't even need a permit. Now, North Carolina, if you're going to carry a gun concealed, you have a concealed carry permit. But let's suppose this is a North Carolina situation. You have John Smith and Robert Doe, and you get a call, a reliable tip. You go to the scene. There's a report of men with guns. You see a man get in a car. The car is stopped. Okay. And remember, you have a pat down now. You've kind of got the extension of the Terry, and there you find a concealed weapon. Well, that's going to give you in North Carolina, that man has committed a very serious crime. He has a firearm that is concealed. Now, any weapon, we have concealed carry for other weapons, so there's a range of it. But at that point, it's entirely possible in North Carolina that we're going to tow your car. We may have an impoundment lot. Now, different police departments have different relationships. Some of them have, some of the larger cities, Boston, New York, Atlanta, Miami, they might actually have a physical impoundment lot, and all the towing might be done by public employees. Smaller jurisdictions are generally going to use something like, they're going to contract out to someone to tow it and store the car. But in this case, we have the car towed, and when the car gets the impoundment lot, there's going to be an inventory search. Now, this search is not done looking for weapons. This search is done for the safety of the impoundment area and to secure the private property of the person. So you don't want to get your car back and you said, well, in my car was, a computer, or in my car was my cell phone, and it's not there now. Well, if we did an inventory search and it says, yes, there's a cell phone on the passenger seat, and we don't have it anymore, well, then the police would have civil liability there. So they found crack cocaine when they searched this one car, and he was convicted. This is United States versus Fields. Now, I didn't necessarily outline this whole case because it's not a Supreme Court case. This is a Seventh Circuit case. Remember, the United States is divided up into a series of circuits, and each circuit, it might be, if you go up to the upper part of the United States, it might be Maine, Vermont, New Hampshire might be in one circuit, and you go out to California, big state, going to be in its own. Texas has got a few people, but this is just a Seventh Circuit. We go up from the Circuit Court of Appeals, then we've got, Supreme Court cases. But basically, this court upheld the search. So inventory searches involving examining and listing people's personal property in containers held in government custody. So a container is anything we use to hold stuff. So these containers will be visually inspected, and items within them will be listed before putting away for safekeeping. Now, obviously, most items that people carry are not criminal by their very nature, but some things instantaneously are. You don't have a right to possess, take an extreme. You don't have a right to possess a nuclear weapon. I don't think we've ever arrested anybody with a nuclear weapon, but you also don't have a right, if we move down that scale, to have a fully operational machine gun. You don't have a right to possess cocaine. And you see how I'm moving down the scale. You don't have a right to possess marijuana in many states. And then it can go even to things like exotic things. Let's suppose I was just reading an article in the paper where a couple was stopped They were smuggling, I kid you not, a tiger into the United States. It was in the, it was sedated, but it was a tiger cub, I believe, and it was in the trunk of their car. Well, think about this kind of scenario. And the reason I'm giving you this kind of crazy scenario is it's going to help you fix it in your mind. Is the police arrest someone for coming to the United States illegally. They then decide, well, we got an inventory search of their car. They open up the trunk, and there's the tiger. Now, it's illegal to smuggle tigers in the United States. So all sorts of permits. But see how that important it is? We didn't try to find evidence they committed a crime. We did this for their safety, for our safety, because you want to open up, you hear some noises at the impoundment lot, you open it up and a tiger comes out, or even worse, the tiger is dead because how long is the people going to be in custody? All right, so let's look at the application of the law. And this first case that we're going to look at is, excuse me, this first case is, this is a Supreme Court case. The other one was not, and this one is South Dakota versus Opperman, 426 U.S. 364, came down in 1976. So the history of this case, and this case is written by Chief Justice Berger. He's the one that's going to write the majority opinion. So Opperman's car was parked illegally. It was ticketed. He was parked in a town, Vermillion, which I honestly don't know where it is in South Dakota. Vermillion, South Dakota, and it's prohibited parking in certain areas, believe it or not, between 2 a.m. and 6 a.m. So early in the morning in December, they see this guy's car, an unoccupied vehicle. At approximately 3 in the morning, they put an overtime sticker on the car. 10 o'clock the same morning, they issue a second ticket, and this is reported, and the car gets towed. So when they get the car brought in, there is an inventory search, and this is that same afternoon. The door's unlocked, and using a standard inventory form, standard procedure, they inventory what's in there. And they open up the glove compartment, which was unlocked, and there in the glove compartment is marijuana. So all these things are removed to the police for safekeeping. And Berger writes the opinion and says, this is okay. This search was based on the idea that you're trying to protect private property. You're trying to protect the police against claims of theft, because you don't want someone that says, okay, the property's been brought into our custody and you stole it, against the police. And of course, and this goes to that kind of comedic example, you don't want the police to be in danger. Now obviously there's not going to be a lot of tiger in trucks in Vermillion, South Dakota in December, but there could be something like a toxic chemical, or God forbid a bomb. So now the dissent, which was written by Justice Marshall, said this was really just a pretext for a search, that the police really didn't have to worry about any of these things. Nonetheless, the majority opinion holds, and these searches are valid. So how do we make sure that these searches are reasonable? And this is going to conclude our looking at it. Well, first of all, it depends upon satisfying two different elements: a balancing of interests and the objective basis. So the balancing of interest is, we're going to first of all protect the owner's stuff. This goes back to that case we just talked about and what was outlined by Berger. We're going to protect your stuff in custody. So if you've got something valuable in the car, we're going to make sure it doesn't get destroyed, lost, or damaged. We're going to protect the law enforcement from private suits, because people might claim, well, you stole my phone, you stole my laptop, you stole what was in the car. And then finally, we're going to protect the police from dangerous items or contraband that might hurt them. Now, the objective basis says this is based upon routine procedures. So one of the things that we're looking for here is is there a routine procedure to do this? If it's not, if every time a car is ticketed we don't tow it, or every time we tow it we don't search it, then we have more of a question. Now we can allow for some discretion. We might say, okay, we generally don't search cars unless XYZ is present. And XYZ might be something like, there's smoke coming out of the car, or it's, something that would make it dangerous. So all these things are, just, factors that can go into establishing an objective basis for a search. All right, let's move on to international borders. And like I said before, you have to understand that you really have a lower expectation of privacy at international border. Not just you, but also anything coming in. And we've got the case, and again, we didn't have to outline this case because it's very brief, and it's U.S. versus Ramsey, came down in 1977. And in this, if you've got an international border, now an international border, as I said, could be a physical border like the United States has, almost all the United States, between Canada or Mexico. Those are the two major countries we border. Obviously, we have a few islands that have international borders, and we have a few military bases where we have some extraterritoriality, but that's very rare. In the Ramsey case, there was a number of letter-sized envelopes coming in from Thailand. Now, Thailand is part of what historically has been called the Golden Triangle. The Golden Triangle is 3 countries in Asia where a lot of opium had come out of. Now, that's kind of been superseded. A lot of opium, drug sources change, but nonetheless, certainly in 1977, it's pretty common that we saw opiates coming in, and opiates are used to make narcotics. So they opened mail coming from Thailand without warrant. And the question is, well, wait a minute, this is a search of a private paper, and if we look at the Fourth Amendment of the Constitution of the United States, the right of the people to be secure in their persons, places, papers, all that's protected, don't we have to have a warrant? And the Supreme Court of the United States said, no, it's not an illegal search and seizure. Border searches are reasonable because they're at international borders. And this is based upon what we've been doing for the past 250 years. So we have a custom statute dated September 25th, 1789, not even 5 years, not even 10 years after the adoption of the Constitution, much less the Bill of Rights. And, that's going to give us the right, or give the government the right to conduct these searches. So quickly then, what I'm going to tell you is you don't have much of an expectation of privacy in these areas, and searches are going to be open. So the border search exception maintains that searches at international borders are reasonable. Again, we do not have to have probable cause. We do not have to have a warrant. The Supreme Court has found that controlling our international borders outweighs limited, and I want to make an emphasis here, limited invasions of individuals' privacy. Now, why can we do these? Well, one of the reasons is we have an interest in protecting who and what comes into the country. Now, once this gets more intrusive, though, then the courts are going to say, well, now we don't want to get involved in this, but we will get involved if you're doing something like a strip search. So if you're strip searching someone for contraband or weapons, you need a reasonable suspicion. So a higher level. Now, obviously, a lot of airports, you just walk through scanners. Those are not strip searches. I don't need reasonable suspicion. I can make everybody walk through a scanner. If we're going to do something incredibly invasive, beyond just a strip search, okay, if we're going to do a body cavity search, there you're going to have probable cause. You're going to have to go to the point that you could arrest them anyway, basically. Probable cause is enough for an arrest. All right, so during the 1970s, let's talk a little bit about these searches. Before most of you were born, of course, there was really an epidemic of airplanes being hijacked. People got on planes. They claimed they had bombs. They said, okay, we've got a bomb. Please, fly this plane to Havana. A lot of them were winding up in Cuba for different reasons. This is really the birth of patting people down coming into airports. They installed metal detectors, x-rays, and began pat downs. And this is just part of our history. The law is, of course, shaped by history. And further, international airports have to deal with immigration issues and the importation of potentially illegal or harmful substances that come in, which really gives us a nice segue to talking more about our airport searches. So, according to the United States Supreme Court, airport searches are reasonable without probable cause or reasonable suspicion if you're doing it for the safety and security of air travelers. Now, here it's not an international border. Here we're just looking at RDU. Let's suppose you're flying between Raleigh and Cincinnati, Ohio. Okay, those are two cities that are inland. There's no international borders in the United States. Can we search? And the answer is, yeah, you can do these general searches. Now, the body cavity search might be a different story. According to the Supreme Court, airport searches are reasonable without suspicion or probable cause, but not all searches. The reason is it's a very minimal invasion, and you're going to be notified in advance that if you're going to fly, you're going to get searched. Now, I was watching a TV program about a gangster who got on a train, and he got off the train, and the guy said, well, why did you take the train? He goes, well, because I'm going to carry a gun, and I'm not going to go through the airport because they're going to find a gun, but you can get on a train without a gun, with a gun. So if you think about it, an airport, someone up in a plane with a pistol endangers everybody in the plane and the plane itself, because, you put enough holes in a plane that's flying, it could crash. True, it's dangerous if someone gets on a train, but yeah, you could be throwing lead around in a passenger compartment and you could hurt people, but you could hurt people in a bank that's a stationary object. You're not going to destroy the train. So you get on a plane, it's dangerous for everybody. We've got a right really to go through this. You get on a train, we do not. All right, let's go to the next very broad one, and this is a big grouping of categories. These are these are custodial related searches. And by custody, let's distinguish first of all between jails, prisons, and other institutions. A prison means that if someone is in a prison, they are incarcerated there because they committed a felony. 99.999% of the times. There's a few exceptions, but we won't talk about them. If you're in a jail, you've either been convicted of a misdemeanor or you're awaiting trial for a misdemeanor or a felony. Now, the other institutions we could talk about mental institutions, we could talk about secured hospital facilities, but you can see that anybody entering areas where there is correctional supervision, there's bad guys in there 99% of the time. So the Supreme Court of the United States has said we can search you without a warrant and without probable cause, without any individualized suspicion if you're coming into a jail or a prison. And the reason for this is we are going to prioritize the safety of the people in the prison and the jail, the people that work there, the people that are also residents there, over any expectation of privacy. And again, this is almost always consensual unless you're being brought in. Now, who can get searched? Well, obviously the prisoners. We can also search the prison cells. We can search anyone who is visiting. We can, and now this is where parolees and probationers raise their head, people that have been convicted of crimes, and people who are detained even if you're not charged yet. So, for example, in North Carolina, you have the right to bring someone into custody without arresting them if they represent a danger to themselves or others. It's a custodial situation. We'd be able to search you. So, we tend to here focus on the prisoners. We do have people that work in prisons and jails. We do have people that visit prisons and jails. But we're going to focus now on the prisoners. All right, so traditionally, prisoners suffered what we often called in the law civil death. When you were convicted of a crime and you were going to be incarcerated, we treated you as dead. You had no rights. You essentially, and that's also been recognized to some extent. There's some debate about this. If you look at the abolition of slavery, slavery ended in 1866, 1865, not by the way of the Emancipation Proclamation, but with the 13th, 14th, and 15th Amendments to the Constitution. But it ended except for involuntary servitude. So we can keep a slave if they're a prisoner. And in fact, this is recognized. Ruffin versus the Commonwealth came down in 1871. It's a Virginia court, now don't get me wrong. But, excuse me, Blair came up from a note here. It says that, basically prisoners are slaves of the state. Gradually, though, there were challenges about this. People began thinking, and I think society changed. We started thinking, prisoners are not these, aliens that have landed among us. They're us. They've screwed up. They're in our custody. They're under our control, but they're us. So prisoners are not beyond the reach of the Constitution, prisons and prisoners. We're going to still have a balancing test between what do we need for safety, what do we need security, what do we need for discipline, and the invasion of privacy. And certainly you're not going to have as many rights as a prisoner in a prison as you do as a private citizen. So, the courts recognize, and this next slide points out, I think, that there is a special need to maintain safety, security, and discipline within a correctional institution. So, and even in Hudson versus Palmer, which really kind of ended this hands-off doctrine, as it was called, or civil death doctrine, imprisonment carries with it the loss of many significant rights. So one of the things we said is, or the court said is, full body searches, strip searches, body cavity searches can be done without probable cause or warrant. In 2005, they went a little bit further, and this was interesting. It said incarcerated felons may be required to provide DNA samples for analysis and storage, and we can make use of that. So let's talk about some of the most intrusive searches that we could see here for people that are in jail and or prison. And these are strip and body cavity searches. Now these are deemed to be, because you got the government doing them, Fourth Amendment searches. But, big but there, okay, the Supreme Court allows them even if we don't have a warrant, even if we don't have a probable cause, because there's a need for safety, security, and discipline. And the expectation of privacy of a jail or prison inmate is very, very low. But please remember, there are different types of inmates. So there can be people that are brought in for very minor offenses like traffic. We read a case earlier in this text about someone who was brought in because her kids were not buckled up in a seatbelt. There are those that are been convicted of a felony. You might have someone that has killed 47 people with a spoon in his basement, and he's been convicted, and now he's awaiting sentencing. Because we're talking about jail inmates here, we're not talking about prisoners. Remember, jails generally hold misdemeanors in people that are awaiting trial, which is our next category. You can have people that are accused of a felony but awaiting trial. Right now in the United States, and I'm recording this in January of 2023, the multiple homicide murders that occurred in Idaho, where we had 4 college students killed, we have a suspect, or the police have a suspect. They just extradited him from Pennsylvania. He'll be going to Idaho to stand trial. He's going to be held in a jail, not a prison, because he has been convicted of anything. He's going to be incarcerated in a jail pending his trial. Now, he may have done it. He might not have done it. But in a jail, if you think, let's suppose he didn't do it, do you want to completely strip him of all his rights simply because the police have made an accusation? Maybe, and I'm not saying there is, but maybe this is a terrible miscarriage of justice and this guy is innocent. Maybe they'll get to trial and they'll compare his DNA with what was found. They'll say, hey, we made a mistake. We got the wrong guy. It happens. And finally, like I mentioned a little bit earlier, there are those people that have been accused of a crime, that have not been accused of a crime, but are being brought in for their own safety. This could be something completely innocent. A police officer finds a small child on the street, takes him to the jail, is holding them in the jail pending the arrival of social services. Not in a jail cell, maybe in just a secured room. Well, let's suppose it's a 10 or 12-year-old. You want to make sure that that 10 or 12-year-old doesn't have a gun or something on him, because they might. So, the next thing to talk about is our custodial related searches. Let's go on to that one. People entering areas of correctional supervision can be searched without warrant. So, people come and visit prisoners. We have millions of people in our prisons and jails. All those people, or almost all those people, have visitors, parents, siblings, spouses, even children. And as they come in, of course, most of them are coming there to visit. Some of them, though, might be coming there to do things like help them break out of the prison, or provide them with illegal substances, or even things like smuggling cell phones, which is a cell phone is a very important instrument inside prison. So people entering or within areas of correctional supervision can be searched without warrant or probable cause, and sometimes without any suspicion. So again, if you're going into a prison, you're not a convict here, you have a lower expectation of privacy. Let's look at a case here where searches are reasonable to further these special needs. This case is Florence Board of Chosen Freeholders of the County of Burlington versus Florence versus the Board of Chosen Freeholders, County of Burlington. Florence was arrested for a very minor fine. He had actually paid it already. Okay. Believe it or not, in 1979, he was arrested after fleeing from police officers in Essex County. He was charged with obstruction of justice and use of a deadly weapon. He entered a plea bargain to 2 lesser offenses, was subject to pay a fine in monthly installments. He fell behind a little bit, failed to appear, but he later caught back up and paid it off less than a week later. However, the database made an error, and they kept this old warrant functioning. And 2 years after he had paid everything off, so the initial crimes committed in 1998, he's paying it off by 2003. 2 years after that, I think we're up to 2005 or so, him and his wife were stopped by a state trooper. The state trooper runs a search for outstanding warrants, comes back that, yeah, he's got this warrant. So he's arrested, and he's taken to Burlington County Detention Center, and he's held there for 6 days, and then he's transferred to the Essex County Correctional Facility. The question was, during this period, he was really subject to body cavity searches, which are very intrusive. Let's be honest about it. These are not something that most people are ever going to enjoy or want. And he sues. And his argument is, first of all, of course, you guys didn't have a basis for this, and you should have searched me. But the Supreme Court of the United States said, even granting all this, now there might be a civil right lawsuit here, but it's really not going to. We're not going to address that per se. And there was a dissenting opinion. The dissent said there were 23,000 searches. Only 3, or 1 as the 2 others have probable cause, found drugs. And a reasonable suspicion for such searches would be much better. So body cavity searches should require reasonable searches. Now, let's go back to this storing and testing of the DNA. All the states and the federal government mandate DNA testing for incarcerated felons. It's hard to underestimate how important DNA testing is to law enforcement. There are dozens of crimes in the past that were never solved because, we found blood at the scene of the crime, but we didn't know who it was. Or, we found hair samples, semen samples, saliva samples, but we don't know who it was. And if you had everybody's drugs, everybody's DNA, then it would be easier to solve crime. Now, one of the things we think, and it has a degree of truth to it, is people who commit crimes very often will commit more crimes in the future. So when we get them, we want their DNA. The Supreme Court of the United States said, yes, this is testing, and it is a search under the Fourth Amendment, but you don't need a warrant for it. Once you're in custody, that's one of the things you lose. And these results can be given to or released to law enforcement. All right, let's move on to a next large group of people, millions of people in the United States, people that are on probation or people who have been paroled. Now, quickly to distinguish between these two. If you're on probation, you've gone to court, you've been convicted of a crime, but you never went to prison. If you're on parole, you went to court, you were convicted, you went to prison or jail, and we let you out early saying we're going to keep an eye on you, just like the parolee, but you've actually served time. So what rights do you have? Well, you do have fewer rights. They are diminished, and we can look at 3 cases here that are mentioned in your text. Griffin versus Wisconsin, and here what we had is you have someone on probation. Remember, they're convicted of a crime, they never serve any time in jail. Probation officer comes and searches the house without a warrant. Court said that was okay. U.S. versus Knight. Could a regular law enforcement officer, so here we're moving from the probation officer, which is supposedly supervising an individual, to the police. 2001, U.S. versus Knight, yes, that's okay. Parolees, again, as you might expect, have even fewer rights. Because if a probationer, we didn't put you in jail, we're going to let you out, usually for a minor crime you're going to get probation. Parolee, usually you've committed a serious crime. Parolees have been convicted in prison but released. They have even, according to Sampson versus California, fewer rights. So, sum this up a little bit. We got a couple more slides. Probationer and parolees have diminished Fourth Amendment rights. They are still technically under state custody, even if they're not incarcerated. And in order to get out of prison or jail, they have agreed, they have contracted. And a lot of law is essentially using the theory of contract. You give me this, I give you that. Quid pro quo. That's a contract in many ways. It's one of the elements of contract. So in this case, you have consented to allow these searches so that I let you out. And we are balancing recidivism versus invasion of privacy. Recidivism is the likelihood that you're going to commit another crime. Okay, to continue with this, you have diminished Fourth Amendment rights. Now, this is a privilege, not a right. It's a very conditional liberty. That tends to be how the courts talk about it. So if we're going to search your homes, I only need reasonable suspicion. And parolees' homes can be searched without warrants or individualized. And parolees have fewer expectations of privacy than probationers. So probationers have a little bit more, parolees have almost none. All right, let's go to people that you haven't been charged with any crime. The Supreme Court has yet to interrogate this issue. They really haven't looked at it. So we really can't say a lot about how this applies. But in this next case, well, let's just move on with that. Let's look at Norris Integrity Solutions. This is a California case. So this is on, well, let's jump into this case. The primary issue here is Norman Norris, okay, and was the search of him, where we have a urine sample here, was this search illegal? Norris was accused of sexual abuse, and he's released pending trial. Now, I want to emphasize here, no conviction, okay? So the police had arrested Norris and charged him with sexually abusing his stepdaughter. He was in jail for 30 days, and then he spent 6 months under house incarceration after posting bond. At this point, he gets completely released under pretrial service monitoring. And under this person, he is freed from this restraint, but he agrees to, again, this is that consent we talked about. Um, the interesting thing is, of course, um, he is ultimately not convicted of the crime he's charged for. So he was forced to strip down and urinate in plain sight to provide samples for drug testing. Because one of the things that happens, and this is not a Supreme Court case, but one of the things that happens in urine testing is people cheat. People cheat all the time. They get clean people's urine, so they'll get a child's urine or somebody else's urine, and then they'll say, well, give me a sample, and they'll provide that sample. And sometimes what they'll do is they'll smuggle urine in a catheter bag or something. So you'll say, okay, here, go in the bathroom and fill it up. They'll take the bag out. They'll pour the clean urine in. They'll give you back the sample. So in order to get the least possible contaminated sample, we force people to strip down and pee in front of other people, sometimes. So the question is this an unreasonable search? This is a circuit court. It's a circuit court opinion. It's not a Supreme Court opinion, but it said it's okay. There is a dissent which says, they're unconvicted individuals. There should be some stronger protections. Supreme Court's not yet looked at it. Well, let's touch something closer to many of my students' interests, and this is searching a college student's dormitory. Now, there's never been, again, a Supreme Court ruling on this, and it's important to recognize that there's a difference between a public and a private college. There's only been about 30 or so appellate cases involving dormitory searches. So we don't have a Supreme Court case. Basically they've adopted some different standards, but the Fourth Amendment only applies if governmental officers are searching. Now, if you've ever lived in a dorm, for example, most dorms are going to have an RA, a resident associate, or basically someone the college puts on that dorm, usually free rent or something, and in return they're supposed to make sure everybody follows the rules. So what's the justification for these searches? There's really three that are looked at to balance things. One, emergencies. Two, the duty to maintain a clean, safe, and well-disciplined environment. And three, the special relationship between the college and the student, because it's kind of an extended adolescence. You're going to go to college. The college is going to have responsibilities to the student. You've probably, if you have a parent, I know I probably said this to my children, I hope I didn't, but I probably did. When you live in my house, you live for my rules. When you live in my college, you live under my rules, and that's going to be consensual searches. Still, having said all this, there is no Supreme Court case on point. We do have an Ohio case, the Ellis case, but we don't have anything that's a Supreme Court case. All right, let's move on to drug testing. Drugs in the workplace are really important, and I want to emphasize here, drugs can include alcohol. The most frequently abused drug that people use is not cocaine, it's not fentanyl, it's alcohol. So one of the things is, why would you search an employee for drug usage? Well, let's take a horrible example. Let's take an airplane pilot. Let's suppose you had a pilot who is going to be responsible for, 50, 100 people's lives, however big the plane is. And he's going to be behind the wheel of the plane, and he drinks. Well, what can we do? How can we reduce this? Well, one of the ways we know we reduce the use of drugs is we test people, and more importantly, I think we tell people we're going to test them. Hey, don't drink before you get behind the wheel of the plane, or the yoke of the plane, because you're subject to testing. So searches to uncover employee drug use through drug testing are directed at the special need to reduce the danger to the public. So who could we think about? Well, bus drivers. Not as critical as pilots, but still pretty critical. Railway engineers, and others who work under the influence of alcohol and drugs. It's reasonable for certain public employees, even without individual suspicion, that they are searched and tested according to different administrative regulations. All right, the final thing to look at, and we do have, if you want to read the case, well, let's move on to the next one here. This is going to be prenatal drug testing in hospitals. Many jurisdictions have started prenatal drug testing in hospitals for women who test positive for drugs after being arrested. And some interesting questions arise here. If you're pregnant and you're doing drugs, okay, yes, you're impacting yourself, but you're also impacting the fetus. And what can we do at this point? Can we even test you for it? Some courts have said, well, if you're going to do this for law enforcement purpose, then you better have a warrant. Others have gone back and forth. Well, let's look at urine tests. We're going to look at the next case here. This is Ferguson versus the City of Charleston. This is 432 U.S. 67. This is a Supreme Court case. Basically, state hospital obstetric patients who are arrested after testing positive for cocaine these are conducted in Charleston, South Carolina Public Hospital, operated by the Medical University of South Carolina. Pregnant women who were tested for drug use were then treated at the hospital without their knowledge, and the results are forwarded to the police. The majority opinion said, and this was written by Justice Stevens, Justice O'Connor joined, Souter joined, Ginsburg joins, Breyer joins, said this is unconstitutional. There's no special needs here. Now the dissenting test, the dissenters, and this is Scalia, Rehnquist, and Thomas, said, no, we should use a special test here, a lower expectation. I think this is really reflective of a debate that you're seeing still in society as to the nature of the fetus, to be honest about you. And you can tie this up in different language. The majority here said the woman's rights, what's being violated. The dissenting opinion focused on, I guess, the fetus right, or the baby's right, if you want to use that terminology. And what would be interesting would be if this case is revisited. This case is 22 years old today when states can ban abortion. There is no federal right to abortion. So suppose you have a state that says a baby is a baby the second of conception. Therefore, any mother who uses drugs is endangering the life of a person. It's a poor analogy, but it would be like that pilot endangering the rights of his passengers. You can see how making abortion illegal opens up a big can of worms here. And, this is something I think that most people don't appreciate. Most people don't understand that change one aspect of the law and you're changing a ton. You open a lot of things up. Law is, one of these things which is just very, very broad, that impacts a lot of things. You change one, you change everything. It's like playing Jenga. All right, let's go to, again, something that a lot of you not too long ago had to deal with, student drug testing in high schools. And we've got a number of cases here. When is it reasonable to test people if you're involved in an activity? Well, we've got a couple cases here about testing in high school. It usually starts off with New Jersey versus TLO, which your book didn't talk a heck of a lot about. But basically, it is reasonable for a school to randomly drug test students who voluntarily participate in athletic contests. And this is kind of, okay, if you decide that you are going to play a sport, and I tell you if you're going to play the sport, I'm going to drug test you, then you should expect it. In Board of Education versus Earl, which is about 7 years later, we expanded this to all students involved in all school activities. And you can see how this could, depending upon the nature of the court, go even further. All right, student searches. What we're going to say about student searches is that minors lack some of the fundamental rights enjoyed by adults. And this is particularly true when you're at school. Now, you don't lack all rights. Much like prisoners, you're not civilly dead. You still have some rights. So the kind of conclusion of the court is you're almost a probationary prisoner, almost a probationary citizen, perhaps would be a better way of looking at it. You don't have full rights. Well, you're in school, particularly a school which is quasi-governmental in its structure, it's publicly funded after all, you don't have the same rights. And drug testing is going to be easier for them to do in these cases. And usually what they're trying to do is balancing compelling interest. So again, I really think that there's a bunch of ones to look at. That Veronica School District versus Acton, that one said, well, random, that is without individualized suspicion, drug testing of all students voluntarily participating in athletic programs was okay. But as we go further, it hasn't been the last word. I just don't think this is well settled for us. I don't think it's something where you can necessarily take it to the banks. So just, bear in mind this is unsettled law. All right, at this point, we're done. We brought it in around 50 minutes to an hour, which is what I like. Whenever you're ready, you can go on to Chapter 8.